Ladies and gentlemen, the conference will begin in 3 minutes. Please return to your seats. We kindly request all participants to turn on your cell phone or set them in a vibration mode and carry your badge with you during the conference. Please be reminded that the breakout session 3, scheduled for 3 p.m. this afternoon, will be held in the ballroom here on the third floor to accommodate video presentations. Kindly refer to the agenda for further details. Thank you for your cooperation. 各位贵宾请注意，研讨会即将于3分钟后开始，请尽速回到您的座位上就座，并请将您的行动电话关机或转为震动模式。会议期间，请随身携带您的名牌，并于中午用餐时于本饭店1楼伯利厅餐厅前向工作人员出示您的名牌后入座。感谢您的配合。此外，提醒您，本日下午3点举行之分组讨论3议程，因影片播放因素，将于3楼大会会场举行。请各位贵宾参阅大会议程说明，感谢您的配合。 Distinguished guests, ladies and gentlemen, welcome to 2024 ICN Merger Workshop. To kick off, we're going to show you a video introducing Taiwan and today's organizer, the Taiwan Fair Trade Commission. Please enjoy.
Taiwan, situated in the western Pacific Ocean, is a mountainous island surrounded by beautiful coastlines. Its abundance of indigenous species is an ecological wonder, and its cultural diversity has created a welcoming home for all. Taiwan has a population of about 23.5 million, which is slightly less than that of Australia. It covers a land area of only 36,197 square kilometers, which is about that of the Netherlands. Taiwan is home to the world's largest semiconductor foundry, and it maintains a leading position in the global bicycle market. The world's first 24-hour bookstore also originated from here. In order to ensure fair competition for all on a level playing field, the Taiwan Fair Trade Commission, with its 7 commissioners and some 200 staff, makes every effort to enforce the law and ensure fair competition. It establishes operational frameworks to keep abreast of emerging trends, reduces the burden that businesses face by relaxing restrictions, and also champions consumer welfare and stability. Participation in international affairs through meetings, workshops, and other events. Establishes solid cooperation and improves enforcement with regulators worldwide. The White Paper on Competition Policy in the Digital Economy received the 2024 Best Antitrust Soft Law Article Award. After more than 3 decades of painstaking efforts accompanied by a strong sense of satisfaction, the Fair Trade Commission continues to strive to keep pace with global trends and become a critical contributing factor to economic stability.
Welcome to Taiwan.
Fair Trade Commission.
So once again, a warm welcome to all of the guests from home and abroad. Now, we would like to invite Ms. Mei Li, Chairperson of the Taiwan Fair Trade Commission, to give us opening remarks. Please welcome her with a round of applause.
Distinguished guests, ladies and gentlemen, good morning. Welcome to the 2024 ICN Merger Workshop in Taipei. I'm Mei Li, the Chairperson of Taiwan Fair Trade Commission, and it's my honor to express a warm welcome to all of you on behalf of TFTC. Your presence greatly encourages us. As to the video you just watched, you can see that Taiwan is well known for not only its beauty and rich culture, but also for its innovative spirit and technology. This dynamic environment is the perfect setting for our discussions on evolving merger control behaviors in today's fast digital era. As we all know, the benefits of mergers lies in expanding resources and drawing upon the skills on each party, enhancing competitiveness. Globalization and the growth of the digital economy have further led to a significant increase in mergers. Now, there are many forms of corporation acquisitions, and the corporations are pursuing global competitive advantage, especially for digital industries, which means companies are using mergers as a tool to grow global competitiveness and navigate rapid economy shifts. However, this trend also brings risks, as over-concentration of market acquisition of a nascent competitor, as well as those of innovation. All of these may endanger consumer interests, along with undermining free and fair trade competition markets. This certainly creates a significant challenge for competition authorities. In response to ongoing market changes, our approaches to merger control must advance to foster innovation while preserving fair and open competition. Therefore, the ICN Merger Workshop provides an invaluable platform for competition authorities and non-governmental advisors to discuss pressing topics. Our agenda includes potential competition, innovation theories of harm, as well as other non-price competitions. I'm confident that our discussions in this workshop will produce new insights for the whole ICN community. The ICN is like a big family, fostering open exchanges and sharing experience in competition enforcement that strengthen us all. This cooperation lies at the core of ICN's mission, making us more effective together. I want to thank each of you for your active engagement and express special thanks to the co-chairs for their invaluable support in managing this workshop. I hope this workshop proves productive and inspiring for everyone. And I also hope you will find time to explore our beautiful city in Taipei. Again, thank you for your participation and have a nice day.
Thank you very much, Chairperson Lee. Please return to your seats. It's now time for a good photo. May I have kindly ask the guests on the left side and the right side, please stand up and gather, and please move forward to a center. 接下来是大合照时间，请左侧及右侧的贵宾请起立。May I kindly ask the guests on the left side and left side, please stand up and move forward to the center. Our photographer will take good photo from the stage. May I ask the guests on this side move toward to the center? Don't be shy. Please move toward the center. cooperation. Please return to your seat. Now, let's move on to Plenary 1 on the assessment of non-price parameters of competition and innovation serious harm in merger investigations. We would like to invite the moderator of this session, Dr. Andy Chi-Ming Chen, Vice Chairperson of the Taiwan Feature Commission, and the speakers, Mrs. Melissa Fisher, Mr. Joe Benford, Mr. Ryan Dunks, Ms. Kala and Josh. Please come up to the stage and have your seat. Please welcome them with a warm round of applause. And now, we would like to give the floor to the moderator, please.
Thank you, Zhe Hao. Good morning, ladies and gentlemen. On behalf of the Taiwan Fair Trade Commission, I would like to welcome you again to Taipei for the ICN Workshop Conference. It is really a privilege for the TFTC to host this ICN merger workshop, and really an honor for me to moderate this first plenary session for this event. The themes of this year's workshop, non-price competition perimeters and innovation theory of harm, resonated with the challenges confronting competition authority worldwide over the past decade when conducting merger review. This trend is largely attributable to the rapid development of digital technology, even though these perimeters and theory can also be applied to beyond the digital market. Digitalization has significantly changed the landscape of market competition and making quality competition perhaps more critical in digital spaces. In this context, the traditional antitrust analytical framework, which focuses more on price perimeter to define relevant market or to assess competitive harms, may become ineffective when products or services on digital platform were offered for free. So in such cases, consumers typically stand to gain, and while the platform operate continue to have, and the market concentration continue to grow, largely due to the prevalent network effects in digital markets. So this dynamic has prompted scholars and enforcers to look for other non-price perimeters to better reflect the market reality of digital competition. And several non-price perimeters, such as quality, product variety, data, and privacy, have been proposed. And among these non-price perimeters, innovation is perhaps the most prominent perimeter that has attracted the attention of the global competition authorities. Innovation is really no stranger to antitrust analysis, especially when innovation is understood as the current efforts to engage in future competition. For a long time, we have been relying on the theory of potential competition to assess the impacts of merger that eliminate the future competitors. But the advancement of digital technology significantly reduces platform operators' cost of using platform as toeholds to enter various similarly unrelated markets. And this is evidenced by the increasing number of conglomerate merger filing for review in recent years. In other words, digitalization has expanded the scope of potentiality in market competition. And similarly, the improved technology of data collection and analytics has enhanced business ability to identify future competitors with greater precision. They are more capable than ever of deferring nascent firms from effective competition by buying them out at their incipiency. Killer acquisition reflects this sort of competitive concerns. So while acknowledging these new competitive harms that may arise from mergers in digital era and attempting to discover the innovative ways to address them, enforcement agencies should also consider the potential competitive benefits this merger can bring. So for example, conglomerate merger can enable firms to create highly integrated business models that facilitate efficient market transaction, benefit the consumer as well as business. So the challenge for the competition authority is to avoid disincentivize business from engaging in such ecosystem competition through excessive application of new perimeters and the theory of harm. So it is the need to evaluate the intricate interplay of those divergent perspectives of merger review that make this plenary session interesting and intriguing. And we are honored to have a fabulous lineup for today's discussion. Each of our panel is experienced enforcer and practitioner, well-versed in competition law and theory. So allow me a minute to introduce them, our distinguished panelists. So to the right is Joe Bedford. I'm sorry. It is Mr. Joe Bradford. Joe was appointed the executive director for merger at the Competition and the Market Authority, CMA, on February 12, 2024. On July 1st, 2024, he became executive director for merger office for the internal market and the subsidy advice unit. Joe is a member of the senior executive team and the board, and leads the merger function to ensure that the CMA deliver an efficient and robust merger control regime. Joe is also the executive lead for the Office for the Internal Market and the Subsidy Advice Unit, supporting the effective operation of the UK internal market and the UK subsidy control regime. Next to Joe is Melissa Fisher. Ms. Melissa Fisher is the Deputy Commissioner of the Merger Directorate at the Canadian Competition Bureau. In this role, Melissa is responsible for leading the Merger Directorate, including overseeing and making recommendations to the Commissioner of Competition and the Senior Deputy Commissioner on all merger-related matters. In addition to being regularly involved in review of very complex mergers, she has also led the member of significant policy initiative, including the director's substantive and the procedure guidelines related to merger review and the remedies, and collaborate often with foreign competition authorities. Prior to joining the Canadian Competition Bureau in 2009, Melissa worked on private practice. And next to Melissa is Mr. Ryan Danks. Ryan Danks is the Director of Civil Enforcement at the Antitrust Division of the U.S. Department of Justice. He has served for more than 20 years as the prosecutor focusing on merger, civil conduct, and the cartel enforcement across a variety of roles at the division. And last but not the least is Ms. Carla and Raja. CALA has the competition and the antitrust and the trade practice at the Raja and the TAM based in Singapore. Her key practice area are competition, trade, and the consumer protection. She also handled employment, environment, and the sustainability, corporate governance, and the telecommunication media law. Carla served on, among others, the board of the Institute for Human Resources Personnel, the external review panel of safety and the SAF, and the appeal board. In 2022, Ms. Carla was awarded the Public Service Star, and in 2014, the Public Service Medal, both conferred by President of Singapore. So welcome. So let's start with the non-price perimeter first. As far as I can remember, in a series of cases, the European Court, the Court of Justice of the European Union has discussed a little bit about the definition of competition on the merits. And in those decisions, the court seems to try to confine and specify the specific perimeters that the European Commission could review. If this kind of decision has any bearing on merger review, it is that probably there are several questions that could be asked first before we delve into the details of the competitive analysis. For example, given the importance, how can an agency define non-price perimeters in practice? And what are the most frequently reviewed non-price perimeter in each jurisdiction? And how do each jurisdiction make decision whether to include or not to include a specific perimeter? I think those are the questions worth asking first. And I know although UK is no longer a EU member, but still I would like to invite Joe first to share with us their experience regarding how do you define non-price perimeter, and how do you set the priority for including or not including each specific non-price perimeters? So Joe, you have the floor.
Thanks, Andy. At least we know this one works. Firstly, thank you for a wonderful event and for having us here in Taipei. So, as you painfully remind us, the UK is no longer part of Europe. Well, the European Union, it is still part of Europe, let's be clear. And we have a long history of assessing non-price effects with respect to mergers. There's the classic phrase which we see written down a lot, the shorthand of PQRS. For those that aren't familiar with the acronym, price, quality, range, and service. And the P gets a lot of the attention, it's fair to say. It gets attention from the economists, it gets attention from the lawyers, and it certainly gets attention from the courts. But in some cases in the past, P is off the table. If we think about healthcare mergers in the UK, for example, that P element, the price, is actually part of the government setting of the agenda. We have a national health service, which is free at the point of care, and so there is no price to the consumer. The price is to the National Health Service, the NHS. But that doesn't mean that there isn't competition on the merits. And so focusing on that quality, range, and service, we've looked at that, I would argue, for decades, and it's developed over time. I'm thinking back here to, as a young case economist, quite a while ago, I will admit, looking at a series of mergers between dental practices, where the advisors would argue that given price is regulated, quality is controlled by the National Health Service, the only thing we could possibly be concerned about is the number of parking spaces, the quality of plants, and potentially how up-to-date the magazines are in the waiting room. Unsurprisingly, that wasn't really going to hold much credit with us with respect to there being no quality control, no quality aspect of mergers or competition in this case. And to illustrate that, we asked the advisors whether their line of argument would lead us to believe that having a single supplier of all dental practices in the UK would be fine because there was a regulated price and a set quality. Unsurprisingly, they weren't necessarily happy to take that position. And I think it's fair to say that that quality element is something we continue to look at. Only last year, we looked in depth at a merger between two suppliers of hearing implants, so bone conductive ones, the ones that go behind the ear and don't actually give the sound through the ear hole. In that case, we saw that innovation and quality of both the product, but also the range of product that was available to customers, again, through the National Health Service, was a vital way that advances in medicine and advances in patient care were delivered. So we've had decades worth of looking at competition on the merits relating to quality, range, and service. But as you quite rightly say, Andy, it isn't only health mergers. And in the last decade, the increase in the number of markets where there's no obvious price paid to consumers has been phenomenal. And although we can still recognize that there is a price to some of us, depending on the amount of ads we may have to look at while we scroll through our social media, the actual time cost or quality reduction is something that we can focus on when we think about that level of competition. It's also been a renewed focus on competition in relation to innovation, which I'm sure we'll turn to. And I think one of the developing themes over the last 3 or 4 years, and I'm sure we'll discuss it in more detail, is not just thinking about innovation around single products and looking at how innovation over that particular product has developed, but actually thinking about that process of rivalry and whether the fact that you have companies striving to innovate and develop products rapidly is something that should be preserved even beyond individual product innovation.
Thank you, Joe. It seems to me that the UK has followed an evolving approach, and probably the perimeter will be determined by the industry that was involved in the review process. So step by step, you build up a framework for taking into account those non-price perimeters. Okay, let's move across the Atlantic Ocean to Canada. Vanessa, we know that there was a recent amendment to the Competition Act in 2024 that broadly empowered the Competition Bureau of Canada to investigate merger cases, including the authority to consider competitive harms in labor market. So can you share with our audience the experience in Canada, especially the recent amendment of the Competition Act? Thank you.
Good morning. I don't think this one's working. Good morning. It's nice to be here. I was going to start off talking a bit about our framework within which we look at non-price effects. Similar to what Joel was saying, like historically, price has been the focus, but we've always had the ability to look at quality, service, range, those kinds of things. But within the last 2 years, our government has made a number of amendments to our mergers law that place greater emphasis on non-price elements of competition. So two years ago, these amendments started, and the first one was to actually specify non-price effects, including quality and choice, within the factors that are in our legislation to be considered. Innovation was already there, but they've included this specific non-price factor, which to us, I mean, although we always thought we could look at it, just the greater emphasis should be put on it. And as was mentioned, at the same time, they also introduced labor as a specific factor to be assessed in the context of merger reviews. And the third thing that they added was a specific reference to consumer privacy. So although this was something we probably could have assessed anyway, they've clarified the law to ensure that where applicable, we're looking at consumer privacy in terms of potential effects on consumers. So that would be, sort of restrictions on data, sharing of confidential information and things like that. So as a result of all of these amendments to our merger laws, we've just launched in the last week a consultation to update our merger enforcement guidelines, which haven't been updated in 10 years. So we've started off the consultation with the publication of a discussion paper, seeking feedback on our stakeholders' views on how the frameworks within which we should look at non-price effects, in addition to labor and privacy, because those were not, neither of which were specifically addressed in our existing guidelines. And then innovation was the other point where we're hoping to engage in some dialogue about specific frameworks within which to analyze innovation, particularly where there's a lack of certainty about overlap or future overlap. We do have some recent jurisprudence, though, that I think is very helpful to us as we think about how to implement these new amendments to our law. Our competition tribunal, which is, this is the administrative tribunal that we would go to challenge a merger or any competitive conduct. They have in earlier decisions already recognized the importance of non-price effects, and that you could find a substantial lessening of competition based solely on non-price effects or a collection of smaller non-price effects. They've also recognized the importance of innovation and stated that dynamic competition is in fact the most important type of competition. And lastly, they've provided us some guidance in terms of the kind of evidence that we should be looking at when we bring a case involving non-price factors. And they've gone as far as to say that we could establish a case based solely on qualitative evidence, if that's all that's available. So that burden to quantify the harm, to the extent that that data or the analysis is not possible, they would be willing to find a substantial lessening of competition based solely on qualitative evidence.
Thank you, Melissa. Just a quick follow-up. You mentioned about the labor issue and privacy protection. We know these two issues probably involve several regulatory agencies. Maybe, for example, usually we have the authority to oversee the protection of data, privacy issue. So how do the competition agency in Canada to reconcile this kind of potential jurisdictional conflicts, if any? And especially when you talk about the labor, does it mean the labor in terms of competitive harms or labor in its own right? For example, labor's welfare, protecting the jobs, employment, something like that. So I think based on your presentation, it seems to me that the Canadian competition agency will focus on competitive harm. Is my understanding correct?
Yeah, in both instances, we're focused solely on the competitive harm. So on the labor side, the harm to workers, whether it's decreased wages, a decrease in working conditions, things like that. And similarly, on the privacy side, it's purely, what's the impact on the consumer?
Thank you. Let's move a little bit south to United States. Okay. So Ryan, I know the DOJ and together with the FTC has published a new merger guideline in 2023. So can you share with us the specific content relating to today's issue, the non-price perimeters, and how do you determine non-price perimeter? And based on your experience, the non-price, how will these perimeters be taken into account in real practice? So Ryan, you have the floor.
Thank you. And thanks again to Andy for hosting this and to the TFTC for hosting us today and for the kind remarks by the chair this morning. It's great to be able to be here. I think that the guidelines encapsulate what has been the agency's longstanding practice with respect to non-price parameters, which is to say that we take into account in all of our merger reviews all of the aspects that my two colleagues have already been discussing here in terms of quality, range, service, and any other aspect of competition outside of the price itself. In fact, it's such an ordinary part of our analysis that just within the last 12 hours, we have filed suit to block a merger based in part on a reduction of quality competition between two healthcare providers in the United States. I'm not going to comment further on that because it is pending litigation, but I would encourage you all to take a look at the complaint that we filed yesterday. I don't know what is time. I'm a little bit confused by the dateline. Filed on Tuesday, November 12th in the United States. And I think that what the new guidelines recognize is that those parameters can play out in all of the sorts of situations that would also be where you would also expect price parameters to be affected. So we can think about it as a loss of head-to-head competition. We can think about it as potentially vulnerable to increased coordination among competitors. And of course, as we're going to talk in a little bit later this morning, and I know throughout the sessions over the next 3 days, it's an important part of how we think about innovation and disruption, not just in digital markets, but in markets really across the economy. And I think that we have seen in a couple of recent cases over the last few years in the United States examples of how this non-price competition can play out. One is our colleagues at the Federal Trade Commission's lawsuit to block the Illumina-Grail merger, where the Court of Appeals in our system recognized the quality competition that would occur between Grail and other testing kit companies, and how that competition may have been affected if the merger had been permitted to continue. And another is actually in a private case, and then this is a sort of classic example of how we can think about concepts in digital markets, but they oftentimes have real-world analogs, and that is a merger. It was a private enforcement action involving door skins, so literally the stuff that goes on the outside of a door. And the argument in that case was that as a result of the merger, one of the main suppliers of door skins had the incentive and in fact had the result of reducing quality to its competitors in the market. And that again was a theory of harm that was recognized and upheld by one of our circuit courts. The last thought I wanted to leave you all with on this is I would encourage everyone to be sensitive to how non-price competition can affect price competition. And there are a couple of examples of this in the non-merger realm of work that has been done over the years. One is an older case in the United States called the Indiana Federation of Dentists case. I don't know what it is about dentists and antitrust law, Joel, but detecting a little bit of a pattern here. And in that case, a group of dentists got together and agreed to withhold X-ray films from insurance companies, even though there was no price component to that agreement. It was clearly done with the purpose of trying to affect how those insurance companies would bargain for reimbursement rates. And so I think it's a good example of how we can bring or should think about non-price dimensions of competition potentially redounding back to affecting price competition. The other example I wanted to give is a more recent example that was an enforcement action that we brought just in the last couple of years involving information exchanges among employers of poultry plant workers in the United States. And to Melissa's point about how conditions of working conditions outside of just wages can be affected as a result of a merger. There, the allegation arose not from a merger, but from an exchange of competitively sensitive information relating to working conditions and wages. But I think it illustrates the sort of harm that we are constantly looking for when we're evaluating mergers and considering whether there will be a substantial lessening in competition under our standard.
Thank you, Ryan. Since you mentioned about the Illumina and Grail case. So I cannot resist the temptation to raise a follow-up because it seems to have different result in EU and the United States, the same case. Okay, I'm the question for the United States. So I think if my understanding is correct, I think Illumina has done divestiture, right? Okay. So, but it's different in the EU because I think the Court of Justice did not agree with the European Commission. So my question is that since innovation is a very important parameter, which we will come later in the second part of our panel, but how is a competition authority clearly describe the dimension of innovation to the business under review in order for them to have a clearer picture regarding the path for the agency's review? Because it seems to be a very general and sometimes abstract idea. Of course, some of the panelists has mentioned about competitive process. We need to protect the competitive process in order to encourage innovation, but still, competitive process seems to be not so clear, vague, a general terminology. So in practice, how did the DOJ deal with this kind of, for business, maybe uncertainty about the review process? Yeah.
So first I should acknowledge, again, that the Illumina case was our colleagues at the Federal Trade Commission, so I'm not as familiar with the record there as I would be if it had been one of ours. But I will say that in general, to your question, Andy, I think that in cases like these, enforcers need to get inside of the documents of the merging parties to understand not only what the current state of innovation and research and development is, but also what their plans are for research and development and innovation in the future. And I do think, and we can talk a little bit more about this in a minute, that there is an important role for innovation in a more abstracted way to play when we're considering mergers, especially in high-tech and fast-moving markets. But I think that in terms of what will be most persuasive to tribunals, at least in the United States, being able to demonstrate the real-world sort of business plans or the real-world actions that the companies are taking are the surest way to success. And I think that the commission in that case, in Illumina, was quite successful at being able to point the court to specific factual development that had been made with respect to Grail's plans to develop testing kits as well as potential competitors or would-be competitors and their plans to enter the market and compete directly with Grail.
Thank you, Ryan. Let's turn to Carla. Carla, you are a very experienced lawyer in Asian region, especially in ASEAN countries. So based on your observation, is there any difference or are there any differences between the eastern part of the world and the western part of the world in terms of the issue we are discussing here, the non-price perimeter? Thank you, Carla.
Thanks very much, Andy. And please allow me to say thank you very much to the TFTC to be present here with this esteemed panel. I feel extremely inadequate. In terms of the countries that I cover, they are very much the Southeast Asian countries because my firm has offices across the region. And so for competition law, we look at countries like Singapore, of course, which is extremely pro-business, but also countries like Indonesia, Thailand, Vietnam, Cambodia, the Philippines, to name some of the more active regulators. And I'm sure there are individuals in the room from these jurisdictions as well, so please do share too. Jumping straight into the question, I think competition law in my part of the world, or actually to respond directly to Andy, to not to disappoint him, the price parameters or the factors that are looked at are not substantially different in the eastern part of the world or in the southeastern part of the world. It's very much similar across the world, but it tends to be nuanced depending on the country you go into. So just going back a little bit in history in terms of the competition law and its introduction into my part of the world, obviously countries like Indonesia, Thailand, Vietnam have had it a lot longer. It's just that it was never enforced, and each of these countries have seen substantial changes in the last 5 years. Singapore had it since 2006 when it came into force, law introduced in 2004, so 20 years of it. The reason I go back in history is I think in the early cases, the focus tended to be on price because it was a low-hanging fruit. It was easier to sort of deal with competition law from a price issue. However, very quickly, I think non-price issues jump into the foray as well. And we loosely talk about price. I like the fact that Joel talked about PQRS, but obliquely we just say price. Invariably, the other elements jump into price as well. And we're always looking at quality. We're looking at the benefits to consumers. That tends to play hugely, even in a country like Singapore, which is super pro-business in all aspects of the work that we do. But if you look at Indonesia, for example, the benefits to consumers tend to figure very highly. Another element which may appear somewhat sensitive is government policy of the day as well. So government policy of the day jumps into what is it that the country is looking to achieve? And that could detract from the primary focus or early focus on price. Yet another element that comes in is in terms of looking at consumer benefits, what quality am I providing them? What options am I providing them? How do I ensure that they do not sort of fall behind? All of that's really looking at non-price parameters. And I think as we do mergers, more and more these elements come in. They come in investigations as well. Yet another key element that's been mentioned is employees. And employees, I think in the last half a decade or so, we talk a lot about them in terms of from an investigation perspective, but from a merger perspective, it's always been a key element. What are the potential implications on employees? We look at non-competes very closely as an ancillary potentially, and we tend to try and see how best we can restrict non-competes, which includes non-solicits as well. And as we look at those elements, one of the key things is key men argument that, or key women argument that you would want to put forward historically and was easier to push has become a little harder. And so you can't get that longer, say 5-year non-compete. Even 3 years tends to be very difficult. And the whole idea is not about price. It's about the freedom of movement of employees. So there's a whole range of different factors. Innovation's been talked about. I think we will circle back to that, so I will not belabor the point. I want to very quickly also talk about data. Data is, again, another element that's come into light maybe in the last 5 to 8 years. And with digital platforms being investigated or merging, or as we talk about killer acquisitions, data figures very heavily. That clearly takes us away from price as well. And how do we assess the fact of whether there's going to be a potential substantial lessening of competition? I recognize that as I'm talking about all of these, I'm just raising questions. But the reality is that's what we do in practice as a private practitioner when you're given a piece of new case. It's always this whole bunch of questions before you try and build the appropriate story to justify why your merger is not going to result in a substantial lessening of competition, or why a potential investigation should go away because it doesn't create an anti-competitive environment. Now, as I speak about all of this, I want to touch on 2 more points. One is sustainability. So coming to Singapore again, Singapore introduced sustainability guidelines 2-3 years ago. It's in force. I know of one case before the commission right now, and I believe it's not public, so I can't share the details. So I know because I'm involved. And it's a case where the focus and the RFIs that have come back from the commission do not focus on just what's the pricing going to be like. They focused very much on the CSI. They focused very much on how different players in the industry could be impacted through this introduction. And it's not really about price. It's about a whole list of other issues that go towards ensuring the competitive elements for competitors, but also potential suppliers and retailers, consumers are not impacted. So you look at a whole range of factors. Now, we've been trying to avoid the clock stoppage. I have another deadline tomorrow. So if it never stops and it doesn't move into a phase 2, because the sustainability guidelines have deadlines in terms of how it operates, the decision will be out sometime in December. Now, my last point to share is a real example looking at aviation. In Singapore, we had a case involving Air India and Tata Sons. Tata Sons, to cut a long story short, it's essentially Vistara, which has ceased to exist. So this is a merger where Tata Sons was going to take over Air India as well. And through that takeover, potentially there were issues involving Vistara, which is a joint venture owned by Singapore Airlines as well. It became a fairly complex transaction because now you're involving 3 different airlines, but 2 of whom are supposedly home carriers with very large market shares, supposedly, allegedly. Merger has been cleared with remedies. I leave you with this and happy to go into this further later. The remedies did not focus on price. So I did early decisions, clearances 20 years ago, 18 years ago, involving the likes of Qantas, British Airways. And the focus there included price as one of the critical elements. But here, price wasn't one of the key elements. We focused on schedules, on capacities. Capacity took the biggest sort of bulk of all negotiations because at the end of the day, it was to ensure consumers continued to have the flights without being prejudiced. One other thing that came up from all the discussions was, what was going to be the profitability of the aircrafts? And we were like, why are you even asking this? But the reality is, if you change the configuration of the planes, you put more in the front of the plane rather than the back, that could have an impact on consumers as well. So I think commissions and, well, private practitioners, we're all leveling up in terms of how we look at transactions as the world evolves, as issues evolve, before we make a call on whether there's going to be an SLC or otherwise. And price is one of several different elements. I pause there. Thanks, Andy.
Thank you, Carla. Just a quick follow-up. I think it's undeniable that each agency will face the constraint of human resources and the budget. So, but non-price perimeter involve a huge array, probably need to be considered if we want to incorporate those factors into consideration in merger review. So based on your experience, when an agency attempted to engage in this kind of review, what kind of help can they ask from the business? For example, what kind of document or material information can they ask the business to provide in order to assist the agency to more correctly assess the non-price effects on a merger, based on your experience? Thank you.
Thank you, Andy. I think different agencies have slightly different styles, and it also depends on the industry before them that they're looking at in terms of the kind of information they would ask. Let me pick up on Vietnam. Vietnam's an interesting country. And when you file a merger in, you have to file a market report. It's not quite your typical economist report, it's a market report. And the market report needs to be prepared by local experts, so to say. And the kind of information that needs to go into that market report, it's your typical market study, but it's also an implication of how that merger is going to impact potentially consumers, industry, how it impacts parallel industries and not just the immediate competitors and so on. It is cumbersome, but that report prepared by a local expert, I think aids the Vietnam Commission to National Competition Authority now to be able to assess their merger. And it doesn't just look at pricing. In relation to, say, using Singapore as an example, the kind of RFI questions that come back historically may have asked for reports by economists, but I think it really comes down to the industry. And it is one of the RFIs, just to share a real example that I received last night, asked questions about, so, you have employees seconded. How are you going to ensure that these employees are going to keep information, CSI, commercially sensitive information, ring-fenced? Are you going to ensure that there are other employees who are independently employed? It's a very granular type question, but these are questions that aid, I think, the regulator or the agency in terms of arriving at how they would determine independence of operation, for example. And the questions go further in terms of how do we manage sort of different competitors. What we're creating is a central body, and how this central body would manage individual other competitors across the board whilst being a central body of a handful of competitors. And the questions that come back look at the quality of the internal controls that will be put together, the quality of systems that will be put together as we collect data from these other parties, rather than what's the price that you're going to charge each and every one as such. I hope this gives you an essence.
Very well, thank you, thank you. Okay, in the interest of time, I think we better move on to the second topic of this panel, is the innovation theories of harm. Before we start, I'd like to quote a paragraph in the OECD Competition Committee's Roundtable in 2023. In the background note, the OECD mentioned, an innovation-specific theory of harm assumes that firms compete through innovation efforts, and where uncertainty regarding future outcomes of innovation effort is high. So in the context of merger review, the described uncertainty regarding future outcome might raise immediately the problems of defining relevant market for innovation competition. And it could also lead to an uncertainty regarding the determination of the overall effect of a merger on innovation competition. So I think it would be helpful for our panelists to share your experience in this regard. So I think I would like to turn first to Ryan. In the very high-profile case of Halliburton and Baker Hughes in 2016, yeah, the DOJ is quite concerned that the two merging parties continue to compete head-to-head in developing advanced technology that were game-changing or disruptive. So you were particularly concerned with the elimination of the kind of the innovative momentum or the killer's instinct. Suppose these two companies remain independently. So I'm just wondering, is there still the line of reasoning when the DOJ reviewing the non-price, especially the innovation theory of harm? Okay.
Yes, I think that that's a good example of what I was describing earlier, where we think about innovation and other non-price theories across the entire range of structures of mergers, including head-to-head competition, and that's still very much what we do today. I think that, you know, in addition to the more abstracted version of innovation that you described, Andy, I would mention that another dimension of innovation that we look at is innovation in business models. And last year, we actually blocked a merger between two airlines. I was thinking about this after Kayla's comments, where one of the airlines had adopted a very different form of marketing and business, like go to customer, than the other. And we saw that that distinction, that innovation, as being an important dimension of competition, not just between those two airlines, but across the entire industry, and sort of a coordinated effects sort of theory. And so those sorts of questions continue to be front and center for us. I think that, you know, as we were discussing earlier, there are some forms of innovation or some examples of innovation where you can see it concretely in the documents and in the current competition between the two parties, and Baker Hughes Halliburton is a great example of that. Illumina Grail, which I spoke about a minute ago, that the FTC did, is another good example of that. I think that there are other forms of innovation that are a little bit harder to get your hands around in terms of where you're going to see the concrete clash between the merging parties in the future. But nonetheless, you can still find reasons to be concerned about mergers in those circumstances if you're looking at the entire ecosystem in which the two companies are operating and seeing how potential innovation competition between the two of them might affect, for example, whether one company might be disrupting a digital platform, for example, either by offering different on-ramps to it or offering customers a potential entirely different model for looking at it. We had a merger recently that was abandoned, I think, that had many of those features to it. And you can also see other examples of innovation that potentially threatens entrenched monopolists or dominant firms with market power. And you want to look for, always want to look for the question of how does competition between these companies present itself now, or how do they think that the competition might present itself in the future. But then the other thing that I am sure that all of the enforcers and all of the private advocates in the room are familiar with, which is, why are they doing the deal? Why do the companies, in their own words, think that this is a deal that is in their economic interest? And oftentimes, if you poke long enough at that question, you will find that there is concern about innovation or competition or disruption that maybe isn't expressed in ways that we traditionally think about it, but that the companies themselves recognize as a feature of the markets that they operate in. And then I think we have to take that and consider it in the broader context when we're making an enforcement decision.
Thank you, Ryan. This is very insightful comments about the standing of the DOJ. Similarly, there's a recent proposed acquisition of Figma by Adobe. I think that the case is a good example to illustrate the issue of innovation theories of harm. And the CMA was specifically concerned that the merger could lead to a substantial lessening of future competition in the supply of screen design software and the several types of creative design software. So Joe, could you elaborate a little bit on the understanding? May not be specific on that case, but what about the CMA's standing regarding the innovation theory of harm?
Thanks, Andy. Disclaimer, because I know that the DOJ and the FTC have talked about this. I work for the parties on that case, so I'm not going to talk about the very specifics of it. But actually, I want to talk a little bit about the evolution to get there, and I'll talk, unsurprisingly, about Illumina, but not in the Grail case. So we'll take it a little further back. But let's set it in context, really. What are we talking about when we talk about effective merger control and the impact on innovation? So what should effective merger control do? It should protect fair, open, and effective competition. And competition from players in a market is a real motivating force. It's the incentive to be more productive. It's the incentive to innovate, and it's the incentive to grow. So if you're thinking about a driver of economic growth, that merger control acts as the engine to ensure that those markets remain open, remain fair, and competition continues to thrive. It's that engine for innovation and productivity, rather than, as some commentators have put it, a handbrake. And I think I want to pick up on the point that Ryan made about, and you asked the question, Andy, very legitimately, how do companies know what the agency is going to be concerned about? And I think it's fair to say the CMA has had an evolving approach when assessing cases that involve dynamic markets and innovation. And that reflects directly upon how those markets themselves have developed. I think it's critical to recognize that the CMA does not carry out its analysis in a vacuum or on top of an ivory tower surrounded by ideological rain clouds. We root our analysis and assessment in the everyday dynamics of how markets work. And the evidence, and this is a strong emphasis, comes from the merging companies themselves. Ryan quite rightly talked about, you read the internal documents. You see how the companies talk about innovation in their market. You talk to their competitors. They talk about innovation in their market. And you talk to their customers and think about what innovation they value. It really is focused on the actual real-world dynamics of the market. And of course, you talk to people. We don't all sit in that ivory tower tapping away on our computers. We go and we talk to people and we try to understand how the markets work. That's the bread and butter of merger control. So we then, at the CMA, put out transparent, fully detailed public decisions, whether it's a substantial lessening of competition finding or a clearance. That gives the market a greater understanding about how we do our work. And we update our merger assessment guidelines, as many agencies, including the US, including the Canadians, are doing frequently, and to bring out the key elements. So to come back to those two cases very quickly, I'm going to go a little bit further back. So if we look at a case involving Illumina, where they aim to buy a company called PacBio. So this is about next generation DNA sequencing, okay? Illumina did something called short read, PacBio did something called long read. The argument at the time from the companies was, never the twain shall meet. There is no medium read, short read and long read will never continue to compete with each other. Lo and behold, COVID comes along, next generation DNA sequencing is vital to that. PacBio was vital, Oxford Nanopore, one of their competitors, were vital. This was a deal that was abandoned in the face of challenge from the CMA and the FTC. And within the last 6 months, Illumina have come out and said, we have now developed long read. We are now doing long read ourselves. It is the future. So you see the innovation, you see the open and fair competition driving further innovation. And one more, just because it resonates very well with the CMA. We looked at a merger a couple of years back involving credit score agencies. So when you get a credit card, you have to go and check your credit score, how much debt have you got, when did you last buy your car, what happened with your house mortgage, okay? In doing that check, that can increase your credit score, make it worse, essentially. And there was one very strong company in the UK. There was then a startup, a challenger. They'd been in operation for 36 months, and they were offered 350 million to buy them out, by the incumbent. We looked at that and we said, actually, the startup, the new player is in there, they're innovating, they're bringing in new data sources, coming back to that issue. They're actually driving innovation for customers, bringing new products, new ways of accessing your credit score. That deal was abandoned in the face of a challenge from the CMA. 4 years later, the CEO and co-founder of that innovative startup has joined the CMA's board because his company has grown for the last 4 years, expanded internationally, put on millions of pounds of revenue, and he sees the value in open and fair competition driven by effective merger control, to the point where he is now a champion for the CMA by joining its board.
Thank you, Joe. I couldn't agree with you more regarding the importance of empirical study. Talk to people, not just sitting in the ivory tower, exploring the possibility of theories. And this is especially the insightful comments for the TFTC because we just proposed a legislative change to incorporate the power to conduct market study by the authority. So thank you very much. So let me turn to Melissa. What is the experience in Canada in terms of the evaluation or assessment of the laws of rivalry competition in terms of innovation?
I was just going to talk about a recent merger that we challenged, and it was based solely on concerns around innovation. And it involved two software producers, and they were producing the software that it's called reserve software, and it's used by medium and large-sized oil and gas producers in Canada to estimate their reserves. And although there were a number of these software providers that produced this reserve software in the market, the merging parties were the only two that had this enhanced functionality that provided the oil and gas companies with an ability to make long-range projections and to comply with tax and sort of royalty requirements in Canada. And my colleagues have both mentioned the importance of the documents. So we had the production of the parties' business documents and their plans with respect to this technology, and it was extremely clear how hard they were competing with one another with respect to their upgrades to the software. So whether it was improvements of existing functionality, new functionality, being on top of changes to the regulatory environment, so that the accuracy of their software was unparalleled. So it was really clear in the documents that they were tracking one another's process. They were going to their customers and marketing their updates to their software. So we challenged the merger just based on the impact to the innovation of this software, because it was really important to the oil and gas companies because it had a significant impact on the efficiency of their operations. We challenged it. We didn't get to go to a hearing because they settled. They divested one of the software platforms so that we could preserve that dynamic competition in the market.
Thank you, Melissa. Carla, what about you, your experience?
Given the time constraint, I just wanted to make a very quick point that as you go out, as agencies go out to gather feedback, market comments and so on to mergers that you're assessing, this is not a cheeky comment, this is a real comment. The comments that come back from the market needs to be taken with a pinch of salt. Because as a private practitioner, time and time again, we look at a merger that's going on and clients would say, nah, that's not going to happen. That's bad. We got to find every way and means to sort of explain why that's bad to the market. Of course, it's all done above board and objectively, but innovation is an low-hanging fruit for competitors to try and put in negative comments as such. I know everyone's aware of it, but just saying that we do put in complaints as well. Always legitimate, yet. Thank you.
Thank you, Carla. As we are moving closer to the end of this discussion, I would like to give each panelist 2 minutes to explore a little bit on the future challenge of incorporating the non-price perimeter and the innovation theory of harm into the analysis process of merger review. And we all know it's quite a challenge for the competition agencies to consider the various dimensions of non-price perimeter that is that is practically very useful for market competition. For example, I think in recent years we have seen that several agencies has changed the rule of evidence for the structural presumption or even shifted the burden of proof to the party under review. So they are all very interesting but real problems for challenging the competition agency in the future. So each panelist will have 2 minutes to share with you experience on this point. I will start with Melissa. So Melissa, you have the first word, our final say of this panel.
Thank you. I'll just quickly mention, I had spoke earlier about a number of amendments to our merger laws. One that I didn't mention was the introduction of rebuttable structural presumptions into our laws. So a merger is assumed to be anti-competitive where the concentration index exceeds 100 points and either the concentration index is, the change is greater than 100 points and the concentration index exceeds 1,800 points, or the market share of the merged parties is 30%. So we've just started to think about how we'll apply that in the context of dynamic markets that are changing very quickly, and how will we ensure that the presumption is accurate as we look forward to the markets.
Thank you, Joe. What about you?
Sure, thanks, Andy. Look, I think over the next few years, we'll have to continue to get the balance right on how mergers can support innovation in rapidly flourishing sectors without closing these new areas to rigorous competition. So that balance between enforcement to ensure innovation continues under fair and open competition versus innovation becoming part of the merger. And look, one of the challenges there is setting it in the context and noting that merger control isn't actually that blocker to innovation and the actual level of intervention in companies' deals, because there's a lot of discussion out there about merger control in the US, Canada, Australia, Asia, UK, and how it disincentivizes companies to undertake these deals in the first place. But if I look just from the UK perspective, I mean, we generally only undertake about 10 in-depth investigations a year out of what, 50,000 M&A transactions across the globe. And last year, I think we had 9. We cleared outright 5 of them. We only actually prohibited one deal out of 50,000, and with the blocker, that seems slightly incongruous. But I mean, there's certainly areas, that we can anticipate future challenges. So let's take one, investments and arrangements in AI. They're going to be really important to drive forwards this tool, okay? This tool that, in theory, can bring miraculous advantages for humanity. But we need to ensure that they don't lead to entrenchment of current market power by a few big firms. And the problem, in some instances, is those arrangements are pretty complex and novel, and they're often driven by incredible funding requirements. So at least within the CMA, our first step has been to use a relatively small handful of investigations to try to bring greater clarity to the market on when we do or do not consider we actually have jurisdiction to review those transactions. And we've used, again, our published decisions to give more information than we normally would on those clearance decisions and why we haven't intervened. And I think in this context, and probably, hopefully across the whole of this workshop, there's more discussion across a few kind of questions that I'd throw to the audience, if possible, not recognizing they're going to put their hands up and answer them right now, but maybe over coffee, lunch, and dinner. So whether a merger itself can lead to further innovation in the context of an ecosystem, for example, cross-product synergies and innovation. Would the same or even a higher level of innovation be achieved without that merger? I think we'll talk about some of that stuff in our breakout sessions and our hypotheticals. And then finally, I'll leave this thought. Whether there are remedies which can solve the competition concern but preserve the merger's ability to pursue greater innovation.
Thank you, Joe. Carla.
Thank you, Andy. I think much as it's very important that we do need to focus on other areas, and if I put it the other way around, much as it is difficult to focus on non-price factors, I think the way the world has evolved, non-price factors are going to be critical. And and recognizing that different countries are going to be focusing on slightly different elements in terms of what they look at for their merger clearances. So when we have cross-border mergers, the focus in each of the countries is going to be slightly different. Trying to gel all of that together is also not easy as you handle the multi-pronged mergers. Now, even as I say that, just one super quick example coming out of Thailand, just to give them some credence as well. Delivery Hero, Food Panda, there was a potential merger in Thailand some time back, and the focus really was all about employees. All about employees, because Thailand was very focused on employees, just to highlight that. Having said all of that, I think even as we talk about innovation, even as we talk about non-price factors, what's come through in the last decade in the world is things move very quickly. So you come up with a set of criteria that may apply for the 1 or 2 or 3 years. That's going to evolve, and it's not going to be firm. So agencies, practitioners, businesses need to recognize there's no fixed set of elements as such, and things will need to keep changing. And when we talk about dynamic markets, it's really not just about the digital world alone. Many years ago in Singapore, we had a forced, this was pre-competition laws in Singapore, we had a forced split in a business, trying to create a second company so that we can create more competition in the market, hopefully more innovation. The companies went bust very quickly, for example. So the forced competition didn't work either. I leave it at that. Thank you, Andy.
Thank you, Carla. Ryan?
3 quick points, echoing somewhat what you've already heard. One, to reinforce what Joel said, the vast majority of mergers that are filed with the United States agencies are cleared without further action, without any kind of even preliminary inquiry. And so as much as conversations like the ones we have today rightfully focus on areas of concern, I think it's important to recognize that the vast majority of deals that happen in our economies are going forward without any type of scrutiny or interference from the enforcement agencies. The second, to Kala's point, we do and should take comments from other industry participants with a pinch of salt. I would say from the merging parties themselves, it's more like a cup. Because we do recognize that everybody is coming into these conversations with their own interests, and the merging parties' interest, most of all, is getting their deal approved. Finally, and again, to pick up on something that Joel said, I think that really one of the most challenging and interesting areas is trying to distinguish between when a merger is going to yield greater innovation and when it's going to allow a dominant firm to deepen the moat that is protecting it from competition. And in some cases, that distinction is easy to see, and in other cases, it can be devilishly difficult. And I think that when I think about the questions that I ask our investigation teams and the questions that we have to wrestle with in trying to decide whether to bring an enforcement action or not, that is oftentimes the crux of the issue that we're grappling with.
Thank you so much. I think there's a commonly shared sentiment around our audience that we wish this dialogue or conversation could continue, but I think we are running out of time for this session. So in the interest of time and with the lingering regret, I need to bring this session to a close. And I undoubtedly, I think the discussion for this panel will lay the foundation for the upcoming breakout session and will enliven the debates or discussion in those breakout sessions. So please join me to thank Joe, Melissa, Ryan, and Carla again for their very valuable insight. Thank you. And I believe also that the coffee, tea, and refreshment are ready. So enjoy your break. Thank you. Thank you so much.
Thank you very much to Vice Chairperson Chen and all of the speakers. Now we have a 20-minute break. The refreshments are served outside the ballroom. Next session will be started here at 10:15. 10:15. Please come back here on time. Thank you for your cooperation.
Hello, hello. Hello. Moshi moshi. Aloha.
Ladies and gentlemen, the conference will begin in 3 minutes. Please return to your seat. Thank you for your cooperation. Distinguished guests, ladies and gentlemen, let's move on to breakout session 1. We would like to invite Ms. Alesta Filtron-Begin to introduce the first hypothetical involving a horizontal merger with potential dynamic competition, including loss of innovation. Ms. Estela, please.
Hi, everyone. It's a real pleasure to be here. Once again, echoing what's been said so far, a very special thank you to our host, the Taiwan Fair Trade Commission, for hosting this great event. I know lots of work and preparation has been put into this, so thank you a lot. As well, on behalf of the ICN merger co-chairs, I just want to thank everyone for their participation in this, not only in this event, but as well as all the mergers working group initiatives, consultations and everything. It's really members' participation that makes everything so great. I'm a bit nervous at public speaking. So this is a first for me. But yeah, I think turning to the agenda for the rest of today, as you know, we'll be turning our minds to a merger hypothetical taking place in the music streaming industry, which we hope you'll all find super interesting. We had really a lot of fun preparing this hypothetical for today. Sorry. So I think you'll have the opportunity to discuss or ask questions to the facilitators in your group with respect to the scenario, but just so everyone is up to speed. The merger, as I said, is taking place in the music streaming industry, and it's the proposed acquisition of Rhythm Feel, which is an up-and-coming competitors in the field. They have developed a new technology, which is said to be very great at recommending special playlists based on your mood and potentially where you are. And it's Streamworks, a major music streaming platform that is proposing to acquire them. So using that case overview, we've provided you as a starting point. Today you'll be discussing different issues related to theories of harm, remedies, as well as investigative tools and techniques, all in the context of this horizontal mergers. I believe there'll be paper copies of this scenario in each of the rooms if ever you need one. In terms of logistics, breakout sessions 1 and 2 will be held in VIP rooms 5 to 7, which is on the 4th floor. Everyone is free to choose the room which you'd like to attend. That being said, I think our TFTC colleagues will be checking on the room capacity to make sure we're divided evenly between the 3 rooms. And in each of those rooms, we've assigned facilitators that will be leading and facilitating discussions throughout the day. We ask that once you choose a room, that you stayed in that room for the whole day, or with your group for the whole day. I think it'll be easier to follow around. Once in the room, like I said, facilitators will provide some further instructions on how the sessions will unfold. If you have any questions on the case scenarios, please ask them. They'll be able to respond, and you can also address them as a group. For breakout session 3, we'll come back here in the plenary room. And I think at the end of the breakout session 2, please confer with your different facilitators and maybe agree on where to meet in the plenary room so you can all be together still. We'll have some interactive videos that we want to present, but there'll still be some questions that you'll be able to discuss as well as a group. And after that session, at the end of the day, we'll stay in plenary room for plenary 2, where some facilitators will present the key takeaways of the discussions we've had today. I think that was all in terms of instructions. Maybe just want to quickly mention that plenary 2 will start at 4:15, not 4, as mentioned in the agenda. We just want to give facilitators enough time to convene with each other and discuss anything before plenary 2. So, with that being said, I hope you have a wonderful day, wonderful time discussing this hypothetical mergers, and we'll see you this afternoon.
Distinguished guests, ladies and gentlemen, the next session is breakout session 1. Please refer to agenda for details and feel free to choose a group to join. The breakout session 1 will take place at the 4th floor. Please proceed to the 4th floor. Thank you for your cooperation.
Hey, hi, good afternoon. My name is Ryan Jakubowski. I'm counsel to
Hi here, it's really
Hey, hi, good afternoon.
Sorry to bother. We have found a USB receiver on the fourth floor. If your mouse or the keyboard cannot work, please find me. There I have a USB receiver.
Attention, please. We found a Bluetooth receiver at a group 2, we believe. And if you miss your Bluetooth receiver, please come to the stage outside the door. And the Plenary 2, we did change our schedule, delayed it to 4:50 p.m. We will delay 15 minutes.另外，我们在中午吃饭的时候有寻获一只手机，台湾人的手机。如果有遗失手机的贵宾，请也是到外面来跟我们领取，谢谢。
Hi, everyone. I think the idea for breakout session 3 will be, and I see a lot of people have started to form smaller groups. So the first half of this session will be kind of the same thing we had in breakout session 1 and 2, so smaller groups discussions led by the facilitators. And then the second half will be showing some videos, which you'll then have some time to react to afterwards within your smaller groups. And at the end of breakout session 3, there'll be this 15-minute pause where facilitators will be able to consult each other's, and then we'll have plenary 2 at the end at 4:15. thank you. Hi. I just want to give everyone the opportunity to finish their sentence, maybe. Okay, I think we're ready for video one. We wanted to do something different, a bit lighter, so bear with us. The idea will be, we'll show 3 different types of scenarios.
Distinguished guests, ladies and gentlemen, welcome back. Now, let's move on to Plenary 2, key takeaways from the discussion on the first hypothetical. We would like to invite the moderator of this session, Mrs. Estela. And we have 5 speakers in this plenary, Ms. Lawrence Berry, Mr. Lucas Cavada, Mr. Tom Nooner, and Mr. Enrique Carrera, and Mr. Alex Baker. You may need to take turns on the stage, so I'll give the floor to Estela. Please welcome them with a warm round of applause.
Oh. Okay, good afternoon, everyone. I hope everyone enjoyed this first day, this first hypothetical. We have a second one tomorrow, which will be very, very great as well. So I think the idea for Plenary 2 will just be to summarize key takeaways from the different groups. It won't last the whole hour. And I think without further ado, we'll go back to the theories of harm discussions we had earlier this morning. And I'll invite Laurence, Lucas, and Alex maybe to provide some key takeaways on each of the groups you've been part of. Laurence, do you want to start?
Yes, thank you. So we had a very good discussion this morning, and I think the case study really provided us with a lot to discuss. We have identified at least 6 theories of harm that could be raised. In that case, obviously not all of them are realistic, but still interesting to discuss. The first one is obviously the idea that we're in a concentrated market with a high HHI increased by the transaction, especially if you look at the future market shares of the party. 45 plus 18 is obviously a high concentration in the market and could entrench the market position of the leader, which is Steamworks. The question is whether this theory of harm is really credible depending on the evolution of the target. Will the target credibly reach 18% of the market in only 2 years? That's a real question. The value of the transaction could give us some insight about whether the parties really believe that is or would be the case. And of course, in that theory of harm, the importance of potential new entrants, including large companies like the GAFAMs, would be very important to assess. Theory of harm number 2 is innovation, obviously. They are allegedly high barriers to entry. The other market players are followers, whereas the target is the only company that have put forward something very innovative in the past 3-4 years at least. In that case, the issue is really that there has been a new entrant that has managed to develop and market a new technology in a very short period of time, only 2 years. They have been successful. They have done this with limited resources, whether it's the amount of money they put in R&D or the number of employees they have. So could that be replicated by someone else? Could another disruptive innovation arise in the market? It's something that we should look at. And of course, is it possible that someone has already in the pipeline something that is as innovative or not? That was something that should be looked at. The third theory of harm is more hypothetical. It's input foreclosure. Mood Reader isn't being licensed to anyone yet, but it could be. Data could also be an input that could be used by other market participants. It's not the case as yet, but for example, if the target needs to finance further research and development, they could license their technology, they could become an important supplier on the market. For this, we would need a lot more data, but it's something that could be imagined in the future.
Yeah, well, that's I think those three theories of harm are really great. Maybe I'll turn it over to Alex and see if you've highlighted anything different in terms of theories of harm or any other key takeaways.
Yes, and to start with, just say a big thank you to the Dream Team in Breakout Room 1. We had a great time during the course of the day, so thank you for the discussion, and to my wingman, Stephen, who outed himself as a jazzy subscriber, yeah, when we get onto remedies, an interesting proposal there. So on market shares, we focus not on future market shares. I'm struggling a bit with the idea that, have people seen Minority Report, the film? Yeah, so we're precogs and stopping the crime before it happens. So we focused on the actual market shares and had a good discussion about whether or not at their current level there was a rebuttable presumption of some harm, some actual harm. For some of the jurisdictions that were represented in the room, I know we're in Sonoria, these shares might have fallen into a safe harbor. So the question of, do we have jurisdiction to look at it? Do we need more innovative ways of asserting jurisdiction came up. There was some discussion about whether the static market shares really told us very much about how competition played out. Only 3% for the target, but what's the change over time? That's the stock, but what's happening with the flow? Are there different market share cuts that you would get that aren't revenue-based that might give you a different impression of how competition is evolving? So looking at the dynamic picture. To the question of this 18%, to the extent we can rely on it, where is that going to come from, and what does that tell us about how different players are competing? If it is the case that the focus of Rhythm Pulse has been independence, and Streamworks has been with the majors, then maybe they don't compete currently. Maybe actually they're focused on different parts of the market and offering something differentiated. So there may not be an impact on actual competition as of today, based on that. There was some discussion about the deal rationale. I don't think this was entirely clear from the materials that were presented. So we were guessing a little bit, but there probably would have been a need to ask lots of questions about why are you doing this? What's the value? We might have intuited something from the remedy offer as to where the value in the deal actually lay for Streamworks, but there was something about the rationale that felt important. Clearly, these streaming markets platforms had two sides to it. You've got the artists on one side and the listeners on the other. So we had quite a bit of discussion about the impact on artists. And we spoke about the concept of single homing or multi-homing for the record labels, and which of, depending on which world we're in, the potential salience of a theory of harm related to the artists. In a world where all artists multi-home, maybe we're less concerned, where record labels single home, and in particular where there might be key artists or parts of the catalogue that are very key to driving consumer switching behaviour, they might be conditions where we're more concerned as well. In terms of the foreclosure, we focus less on data and tech and on recorded music as an input, and had a discussion around whether or not the ability or incentive for record labels to enter into well, whether exclusive deals existed, and therefore, depending on that, whether the ability and incentive to engage in foreclosure behaviour occurred. Clearly, there was a complainant, a third party, that felt that this merger would impact their ability to access catalogue. But there, I don't know that we felt in the room. There was some discussion about whether or not that worry was founded. Final couple of points from our room. We did discuss coordinated effects and whether or not a change as a result of the merger might make certain key parameters of competition better focal points for coordination, so price, consumer terms, with the elimination of a potential maverick competitor in the market. Do you create conditions where coordination is more likely? And there was some discussion about privacy, so some concerns expressed in the room about the impact of the transaction on what looked like differentiated approaches to privacy policies. But the question arises, is that a key driver of competition in the market or not? Or are other factors more important? And what does the merger change? That's the really important question when it comes to merger control, is what is the impact of the deal, rather than do you have too permissive privacy legislation, or is there some other reason why the behavior is as it is in the market? So that sort of summarizes what we discussed.
Thank you. Thank you, Alex. Lawrence, I saw you nodded at privacy, so maybe we'll get back to you at the end. But Lucas, anything you wanted to share with respect to key takeaways in Group 3?
Yeah, well, please allow me to start by thanking Estelle and team for putting this hypothetical together. I think really amazing work, so thank you for that. Well, we had a very lively discussion, which I appreciated, and so much has already been said, so I will try to focus on a few points from our discussion. First of all, there was the question whether this transaction will cause any harm. Well, we agreed that yes, to some extent. So who will be harmed? So we had, and how? So we had basically discussions on consumers, music producers, artists, and streaming service competitors. A very interesting conversation and discussion was on transaction or purchase price, because some argued that this would help to assess how valuable the technology really is, and I think that's actually a very interesting consideration. We also had discussions on the relevant market and whether the innovation market or development market could be even worldwide, and how that would influence the assessment. Some also argued in terms of market shares that having market shares from previous year would help to explain dynamics. And what we also discussed, and I really found this interesting, would evidence of harm in other jurisdictions impact sonorous analysis. I think that was really an interesting aspect as well. And what we also discussed in more detail is, in principle, switching seems easy, but do people really switch between various platforms? So this was basically, I think, the main points we discussed that are different from those we already heard. And it was really interesting, and thank you to everyone who really participated actively.
Thank you, Lucas. I'll get back to you, but Alex, I see you want to jump in quickly.
Just very quickly on, is anyone actually harmed and what are we trying to protect? In the UK, we've had a music streaming market study, and there were lots of concerns that resulted in that market study about discoverability of artists, and it's on the artist side. You know, how do these tools and platforms impact the ability for artists to make money? What does that do over time to the creative ecosystem, if you like? It's just an interesting thought that the technology that we're focused on in this hypothetical has an algorithm where it makes it more likely that artists will be obscured rather than discovered, given the engine. And there's just a question of what is it we're trying to protect, and is that a good thing? We did have a bit of discussion about that, but it's just worth reflecting on, because just because it's new doesn't mean it's good, if I can put it that way. We might all have a different view, by the way, if Facebook arrived today and was this big new innovative sort of algorithmic platform, about whether or not preserving it would be a good thing or not. So just an additional thought on the theories of harm.
Thank you, Alex. Laurence?
Jumping in on privacy, because we had a very interesting discussion. First, on the fact that obviously not all agencies could actually intervene based on pure harm to privacy, as opposed to data privacy agencies. And so how, in the world of competition law, you take that into account? And we thought that first, if customers actually care for it, and there we had a discussion, very interesting, between stated preferences versus revealed preferences. Like, you say you care for privacy, but do you actually act on it? If customers do, obviously it's something that competition agencies should take into account. And also, even if it's just stated preferences, customers say they do care about it, but don't necessarily act. If companies active in the market do take that into account to shape their strategies going forward, then we agreed that it was probably something that competition agencies should take into account and should see as a parameter of the quality of the product. And so a decrease in the protection of privacy should be something that is also taken into account in a theory of harm.
Thank you. Yeah, thank you to the three of you for this this very great overview. I think now we'll move on to breakout session 2 on remedies. Enrique, if you want to come to the stage and join us as well. For this one, we'll have Enrique from Group 3 delivering the key takeaways, as well as Tom from Group 2 and Alex again from Group 1. I think Lucas mentioned I was in Group 3 that we had lively discussions around theories of harm. I think they were even more lively when it came to remedies, but we'll hear more about that in a few seconds. Tom, do you want to start with?
Sure, and first of all, I just want to congratulate you on the hypothetical. I thought it was a great hypothetical, and I've already sent it to my training team to copy and use at the ACCC. So we actually, I mean, we did talk about the remedies in the matter, and I'll get to that, but we started just by talking about war stories of all the terrible divestments we've accepted that have gone catastrophically wrong. And, you know, those behavioural remedies we've sort of deeply regretted for 10 years after the fact. And I think it's really useful to talk through those war stories because it teaches you a lesson. It's always tempting to sort of accept a remedy, get a matter off your plate as a regulator, but then you pay the costs, or the consumers pay the costs, you know, in the long term, potentially for those behavioural remedies that are circumvented or aren't working. And as a regulator, you pay the costs for trying to enforce that remedy, trying to, you know, dedicate resources to it. So I found that a great discussion. It was great to see that we all had shared experiences, and just the openness about how we've got it wrong, you know, over the years was really good. But having sort of beat ourselves up and getting all depressed about remedies, we then turned to this remedy, which in essence is divesting the IP, the mood reader tech, Project Groove, R&D. We, in essence, just thought it was pretty awful. So no one seemed to like the remedy. We thought there was very high risks that the buyer, well, which buyer? That's the big question. Is there a buyer out there? We thought they're very high risk they wouldn't be able to integrate the IP with the rest of their business, for example. There seemed to be a huge employee exit risk because there's only a handful of employees working on this tech, presumably a few critical engineers or, you know, IT people. And if they left, that would pretty much kill the divestiture assets. And I think the fundamental flaw here, and it kind of came out of our war stories earlier, is that the assets that are proposed to divest are not a standalone business. It's not something, it's just a collection of sort of IP rights, some staff, and that creates huge risks with you know, a divestment process. Potentially, if you had an upfront purchaser that, you know, was very certain they wanted those assets and knew what they were doing, there potentially could be a path there, but I think you would really want to make sure of that. And look, then we kind of moved on to just general talking about remedies and stuff, and we had a great discussion about which regulators have a remedies specialist team, which I found fascinating. It's a really mixed group. So some of us have a remedies specialisation group. At the ACCC, there's 4 or 5 people, but others don't, and just the pros and cons. We spoke about the importance of international liaison on remedies, and basically the theme there was just, you know, when it gets to negotiating remedies, you've just got to have really, really open communication between the regulators and frequent discussions. And how there have actually been a few hiccups over the years, you know, between regulators taking different positions on the approved purchaser and things like that. Really got to watch out for those issues. And then we spoke a little bit of a sort of small jurisdiction perspective in our group, like when do you piggyback off the big jurisdictions? So when do you sort of say, look, Europe or the US have negotiated this good global remedy, we can just pens down and kind of piggyback off that. And how do you piggyback? Do you insist on your own remedy, or do you just rely on the US and Europe enforcing their remedy? How do you sort of do that efficiently, and the risks of the different approaches? So they were our main topics. Thank you.
Amazing, yeah. Looks like there was very interesting discussions going on. Enrique, do you want to share what happened in Group 3?
Yes. So thank you, everyone, for your participation, especially those in Group 3. You were amazing. So this is just a summary of what went on. So in principle, we had a very good discussion where views have been exchanged. And the summary is the following. So in principle, what we saw is that the remedy package suggested by the authority may be disproportionate in the sense that it may kill the business rationale of the transaction and the deal. We had other views in the room saying that the package was suitable and in fact, selling to another competitor would not solve the main issue here, which is innovation, right? You just transfer the problem. We also discussed the point of some jurisdictions only accepting structural remedies. So we tried to find a middle ground solution, right? So we also discussed, of course, the pros and cons of structural versus behavioral. And as I mentioned, the solution, or the middle ground solution we found was designed in order to keep the benefits of the transaction while protecting innovation. And we considered 2 options. So first one would be a partial divestiture, and just divest project group, while the buyer will keep the mood reader technology. The second option we discuss is a license. Basically licensing the technology on a front basis. So of course this needs to be tested with competitors, and we also found that perhaps in terms of workability of the remedy, perhaps an upfront buyer solution will be the right option. As to the geographical scope of this license, we discussed whether it should be local or global, and coming back to the piggyback point. A local license, we kind of agreed that will not solve the issue, so we have discussed whether that license should be global. And this was pretty much our discussion.
Thank you. Alex, anything different, any similarities in group one?
A lot of what we discussed has been picked up already. Our middle way was to prohibit, not to license. A couple were in favour, but I guess this goes to what is the theory of harm? What's the value in the business being acquired? And is it just the catalogue? Is it just the innovation? Is it something about the combination of the two? And if you're in the world where it's the combination of the two, maybe prohibition is the right thing to seek. We also discussed in the hypothetical, this is a court-based system, not an administrative system. So we're going to have to go in front of a judge and make arguments. And there was some discussion from those who have experience of that, the challenges potentially of that form of interaction, and where you end up with the specific remedies. A couple of other builds. So we did discuss licensing, and a different version of that is open sourcing. So if actually what you're worried about is how this innovation diffuses in the market and spurs competition, maybe you take a version of the technology and open source it, and then you level up the market and then see what happens with all of the larger players potentially having that technology, not necessarily licensing it on an ongoing basis. You get into all sorts of difficulties around, well, do updates get licensing? What's the support? Who's going to monitor this? How can it be enforced, and so on? We did speak a bit about who's going to buy this stuff, and that ranged from discussions around private equity and trade as potential purchasers. Stephen wanted Jazzy to acquire the catalogue so that it would diversify into different music strands and become a stronger competitor. We also, because some of the agencies represented in the room have public interest elements in their law, spoke about the impact on the employees in Sonoria who wouldn't be part of the divestment package and what would happen to them. I think 10 of the 26 employees don't appear to be working on innovation and R&D, so are they part of the efficiencies that would accrue by virtue of the merger? And is there something in the law that means we should think about the impact of them? I realise that isn't a provision in many jurisdictions, but it is for some. So the public interest element was another aspect we spoke about. We did also, finally, to conclude, discuss how we would argue against the catalogue as a divestment package, because Streamworks said it would tell the court that this would be an ideal solution, beyond just saying this doesn't remedy what we think our theories of harm are, or what the court has decided the theory of harm is. These are contracts, and there are counterparties to contracts, and it can be difficult sometimes to encourage the counterparties to accept the remedy. So would the contracts be terminated? Would there be change of control in there? Would the behaviour of the record label shift after you try and implement the remedy? So we saw some challenges with the proposed remedy from Streamworks.
Thank you. Tom, Enrique, anything you wanted to add after that? No? Okay. Well, I think the key takeaways maybe is that there weren't any clear-cut solution right off the bat, and that theories of harm would have been needed to be pinned down before deciding on anything. Great. And for our last breakout sessions, I think Alex and Tom may speak to that. Enrique, you're welcome to speak to that as well. Yeah, okay, perfect. Yeah, so our discussions on investigative tools and techniques, followed by our very good actors from the Competition Bureau, I must say. Enrique, do you wanna start?
So we had some exchanges about how the case handlers, at least in the first video, prompt the council in a weird way somehow, in the sense that, you know, no information was provided. And we also thought that the request made by the authority made no sense, in the sense that perhaps that information is not required to conduct a proper analysis. It's too granular. On the second video, we came across a situation whereby the authority was not even ready to disclose where did they get the contact information, which came across a little bit weird also. We have discussed also several scenarios where we've seen as practitioners, and we had lively discussion also from the side of the authorities, indicating in which situations internal documents are very relevant. We saw Alvaro contributed a very nice point saying that in principle boards have to be ready to demonstrate why are they spending their money, and that's probably the key document to look at, and how they're going to recoup that investment in the future. So that's also a very valid point in terms of which documents are relevant in order to assess the transaction.
Tom, do you want to?
So we went through what we would request in terms of documents, data. We also spoke about consumer surveys and then interviews. So documents, there was a bit of discussion about whether you sort of go the standard document request, which most jurisdictions have, you know, give us the documents that talk about competition in the industry or competitive dynamics or things like that. And, you know, they're pretty standard, but they're very subjective, so you can often miss key documents. And then so we talked about more objective document requests. For example, in a request to, sorry, I've forgotten the name of the main company, Streamworks, you might ask for any email that mentions rhythm feel. It's very objective. They can't not, you know, easily pick those documents out. And if Streamworks executives are talking about rhythm feel, it's probably going to be interesting from a competition perspective. Or any document that mentions Project Groove or whatever word is used for Project Groove in the industry. You know, you might go and work out what the industry lingo is first before you issue your document request. And we spoke a bit about interviews. I mean, the feedback on those interviews, you know, the importance of open questioning, building a relationship and preparation. And, you know, the second video obviously had very closed questioning, probably breached confidentiality, a bunch of problems there. On the first interview, I mean, we had different takes on that first one. I think it was because we had different contexts. A few of us said they would have, if they were the regulator there, they would have immediately hung up, which I found interesting because the person from the company was raising issues. There was supposed to be a call about data, and they started questioning about where the competition analysis was at. So that was interesting. But obviously, yeah, there was, I think that was fairly well handled from the regulator sort of perspective on that one. One thing about interviews, we thought as a regulator it'd be important to try and get in early with particularly some of the sort of IT tech people at the target firm, to sort of get in before they're too well prepped and before they understand the case theory against them too well, get them talking about, you know, this great technology, and you could probably get some good evidence there as a regulator about what really is going on in that target firm and what its prospects are. Then we spoke quite a bit about data, what data we request. Switching data, you know, can we track where consumers are switching from one company to the next? the price series data, you know, how has price changed over time, you know, whether people are using free versus paid. And then, you know, this morning we spoke in the plenary a lot about the quality metrics. And are there quality metrics here? And there are a couple that, you know, you could look at. One would be for the free element of the services, how much advertising is the listener subject to, and how has that changed over time? Because the amount of advertising is effectively their price, in a sense. You know, the number of songs that are on the service is another sort of quality metric. The number of downloads, you know, they spoke about you can download 3,000 songs to your device. You know, that's another sort of quality metric that you could probably get some great data about. We also spoke a little bit about consumer surveys, and this was, you know, maybe, and we're not saying you could consider a consumer survey to get a sense of whether the Rhythm Feel product, what is it actually, this new technology, are consumers actually valuing it or not? There could be space for a consumer survey there, and we had a bit of a debate about, you know, the benefits and costs of consumer surveys.
Thank you. And I want to reassure everyone that that's not how we conduct interview at the Competition Bureau. Alex.
Some great acting ability in the videos, so they definitely added something to the afternoon. To complement the comments that have already been made, I think given some of our discussion around the limitations of static market shares, just trying to think about what will give you a picture of how things have changed over time, and that dynamic element, maybe app downloads or something of that sort that would help with that. There was quite a bit of discussion in our group around some sort of procedural considerations when you're asking for evidence. I mean, clearly one of the things, you've got to balance trying to get to the right answer with how onerous the requests are and the proportionality of that. Clearly, some repeat users of competition authorities will think about how they produce their internal documents, if that's going to be a key source, so they may be of more limited informational value. I like the idea that you need to get in early before they know what they're into in order to get useful information, but there might be limitations in the standard set of documents, strategy documents, board papers, and so on. Another key question is when the documents were produced. So quite often documents, I'm certainly talking about UK practice, but documents produced after the merger has been announced or discussions have been started tend to place less value and weight on those, the ones that were produced before. But this is a nascent market, so clearly there isn't going to be 20 years of documentary history. It's going to be more limited than that. So what is the time period that's the most relevant in this case? The importance of keywords and thinking about the scope of some of the requests, particularly when you're talking about emails and other forms of communication. The point was made, actually it's compared to 20 years ago when you would get a lever arch file of documents, now there could be thousands or millions of communications that contain relevant keywords spread across different modes, not just email, but Teams chats, WhatsApp messages. So just thinking about how do you really hone in on what's going to be most valuable and not boil the ocean. The incentives of different people that you might interact with. So even within companies, there might be a split in the view of the market or the deal between the board and the executive and those who work at levels below the senior management team in an organization. There may be incentives on third parties to give motivated responses to requests for information. You may have looked at mergers in this sector in the past, so there might be some stuff that you've already got on the books, precedent cases and so on, that can help navigate your way through this. And then we had a bit of discussion about what is the right time, if this is a deal that's notified in many jurisdictions, to engage with the parties about potentially a waiver and sharing information that has been provided to other agencies. So that's on the evidence side. On the calls, I think we struggled a bit more with the positive stuff in general across the two calls. But what the positive things on the case handler call, we thought council was trying to be constructive. There was, you know, we've got this issue. Can we explore it in terms of his approach? I offered the view in defence of the agency, even though the tone was quite robust, that sometimes agencies need to stand up for their own process. You know, so what? Another jurisdiction isn't asking for this. Doesn't matter. We've got our own law, our own issues, and we need to try and get the right answer. So that robust position, not necessarily a bad thing. And there was an offer at the end. You know, we haven't specified the key personnel, but if this is an issue for you, let's engage in some dialogue. There was an open door. In terms of the case handler call, things that might be things to reflect on. Was the statement at the beginning about the view on the case giving a sense that the prejudged the outcome, was that helpful or not? And maybe these were the wrong people talking to the wrong people. If the issue is around data and so on, could it be that the data scientists, or if you have them in your agency, or the people who are going to use the data, could speak to the relevant people in the business to really work out what's feasible and what have you? And in terms of the interview at the end, I'll just pick out one or two things. So the preamble, maybe it would have been helpful to send some information in advance about how the information would be used, what would be confidential, what wouldn't be, even though the caller appeared to breach their own confidentiality considerations during the call. And it might have set the discussion up in a different way, rather than saying, well, I'm not going to tell you where I got your contact details from, just to get that out of the way, either with a pre-call or via email, and then focusing on the questions. And again, something about questioning technique, that dynamic process of questioning, listening to the responses you get. Well, our prices are far apart. There's a follow-up question there. Why is that? How different are they? Can you explain that to me? Being a bit more open in the questioning rather than closed. Something about the technique, and maybe having a colleague there to take the pressure off. So there clearly was a script, but it might have been better to have someone to help out, just to ensure that you're getting the information that you need.
Thank you. Yeah, those are certainly good suggestions. And I think, yeah, I think what came through is really in terms of structuring our review, how important is it to plan, to strategize, and think about what we're going to ask, what we're going to need, and why we're going to need that information. So thank you all for your participation. Thank you to the other facilitators as well, Stephen, Lucas, Laurence, Martin, Xingyuan. I don't see you, but thank you all for your help today. This has been, I think, a very interesting discussions. Thank you.
Once again, a warm round of applause to the moderator and all of the speakers. The agenda for the first day has now concluded. Thank you to you all distinguished guests for your participation. Please remind to take your personal belongings with you when you leave. Tomorrow's agenda will begin at 8:30 a.m. We're looking forward to seeing you tomorrow. For guests attending the dinner event, please join us at 6 p.m. in the Noble House on the first floor of this hotel. And please don't forget to carry your badge with you when you have dinner. Thank you for your cooperation.